looks like my next available bench trial. Oh, this is a city case. So I'm looking at Fridays. Well, we could do as early as April the 19th. We could do the 19th or the 26th. The 19th, 26th, and May 3rd. I have those 3 consecutive Fridays available.
I'm good on the 26th if this good with Shannon.
That's fine with me.
All right, then I will set this. Oh, before I do that, I'm getting a little bit ahead of myself. Mr. Selman, by his words, your lawyer is indicating that you want to waive your right to a jury trial and have the case heard by me. Is that what you want to do?
Yes.
And sir, do you understand that if I accept a waiver from you today, you will not have a jury to hear your case, that I would be the only decision maker?
Yes, Your Honor.
Has anyone threatened you in any way or promised you anything to get you to waive your right to a jury that wasn't placed on this record?
No.
Any objection from the people?
No objection, Judge.
Having no objection from the people, finding that the waiver has been made freely, knowingly, and voluntarily, I accept the waiver and set a bench trial for April the 26th, 2024 at 10:30 a.m. Do we need a final pretrial conference the Friday before, or we're all set?
I think we're all set.
I don't.
Okay, then we're all set. Have a great day. Stay safe.
Thank you, Judge.
Thank you, Judge.
You're welcome. Wait, what did I just do? I put him in the waiting room. I didn't try to do that. I meant to remove him. All right. Okay, I think even though I don't see them at a table, I think you all told me that the Attorney General that I've been waiting for on the Johnson case is present in court. I don't see anybody at the table.
Yes, Your Honor. He just stepped out to the restroom.
Oh, of course, because I was getting ready to call the case. Of course. Step out.
He just came back. Your Honor.
Why is this attorney saying attorney for Barraza? I already did that case. Oh, see, somebody, okay. Okay, so that's on Johnson and so Miss Counsel, is your name long A Crapo or short A?
Long A, Judge. Crapo like a crepe. It's
Okay,
French.
thank you. Thank you. Ms. Crapo, so I'm going to take this case first with Mr. Frazier. He's been waiting a little bit for the AG, and then I'll be ready for you. Mr. Clayton, someone already came and we did Barraza.
Okay.
Another
Thank you.
came. I forget his name.
I had sent out a text message, but because I was stuck in a hearing, so I wasn't sure. Thank you, Judge.
All right.
Appreciate
You're
it.
welcome. Okay, have a great day. Stay safe.
You too.
Mr. Frazier, I'm ready for you and your client. I'm ready on Johnson. The AG is here. Mr. Frazier, you getting ready to lose your place in line.
I can text him, Your Honor, and let him know that you're
Yeah, I'm here.
No, he's here. Thank you, counsel. He's here. All right. Start. Okay, we're on the record with case number 224565101, the people versus Richard Todd Frazier. Defendant is charged with 1 count of malicious destruction of property. Today is the date set for final pretrial conference. Appearances, please.
Your Honor, John Frazier appearing on behalf of the defendant. His name is Richard Todd Johnson.
Oh, what did I say?
You said Frazier, that's me.
Oh, I'm so sorry. And I'm looking
No
dead
problem.
at his name, Richard Todd Johnson. Okay, I'm sorry. I apologize. Thank you.
Good
Oh,
morning.
but you went ahead of your time. Mr. Prosecutor, can you state your appearance, please?
I will, Your Honor. Good morning. May it please this honorable court, Mike Frezza, Assistant Attorney General, P 46949.
And then Mr. Johnson, can you state your name for the record?
Richard Todd Johnson.
Thank you. All right, today is the day set for final pretrial conference. Mr. Frazier, how are we proceeding?
Your Honor, I've had the opportunity to discuss this matter with the Assistant Attorney General. We have a plea agreement whereby Mr. Johnson is going to be tendering a plea of guilty to malicious destruction of property, more than 200, but less than 1,000. That would be a delayed sentence under section 771.1 to be dismissed upon the payment of $417.64 in restitution, and what other terms the court feels that it would be appropriate in this case.
Counsel, I do apologize because I rely heavily, look, I don't know what I did before Zoom, but I rely heavily on seeing the people's names on the screen. Mr. Prosecutor, tell me your name again.
It is Frezza, spelled F like Frank, R like Robert, E like Edward, C like zebra, Z like zebra, A like apple.
Thank you. And then you all names almost close together. Frezza and Fraser. Okay. So Mr. Frezza, is that the people's offer? Is that the people's offer? I'm sorry.
It is, Your Honor, and to the extent that the written plea agreement has been communicated to your honorable clerk, I believe the additional term and condition says that the defendant will pay restitution of $417.64 in favor of Motor City Casino prior to any dismissal. It is under MCL 771.1. As I understand that statute, that is up to Your Honor to craft whatever it is that this court determines is the appropriate remedy. People would not oppose dismissal once whatever terms and conditions that Your Honor sets are fulfilled. In that regard, all other terms and conditions of the sentence will be set by this court.
Okay, thank you. Ms. Hernandez, you can leave. That defendant never showed up. Okay, so thank you. And if they show up before I finish the docket, I'll have Mr. Flanagan try to call you, but they're not here.
Thank you, Your Honor. I appreciate it. Have a good day.
Okay, you too. Okay.
Thanks.
Bye-bye. Ms. Crapo, also before I get into taking the plea, did you need to speak with your client in a breakout room, or are you all set?
My client's in my office. So while you were addressing this, I just stepped out and spoke with him.
Oh, even though they're in the breakout room?
Yeah, that's how we do it. We have like a laptop that we allow our clients, or multiple laptops we allow our clients to use if they're more comfortable being in our office.
Oh, that's great. Okay. I'll be with you shortly. Thank you. Okay, Mr. Johnson, your lawyer has indicated that you want to waive your right to a trial and enter into a plea today. Is that what you want to do?
Yes.
And okay. And I'm going to share my screen, and on the screen you will see a constitutional rights form. Okay. With respect to the constitutional rights form, sir, my question to you is, have you had an opportunity to go over your constitutional rights with your lawyer or on your own?
Yes.
When you did that, did you understand your rights?
Yes.
Sir, do you understand that this is a misdemeanor, and therefore, as stated in number 5, you have a right to a trial? But if I accept your plea from you today, as stated in number 6, you're going to be giving up your right to a trial. Do you understand?
Yes.
Has anyone threatened you in any way or promised you anything that was not placed on the record today to get you to enter into this voluntary plea?
No.
Are you currently on probation or parole?
No.
finally drawing your attention to number 11 on the advice of rights form. Do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would either have to request permission of this court to set aside your guilty plea or request permission of the circuit court to appeal the conviction.
Yes.
With that understanding, do you still want to give up your right to a trial and enter into this voluntary plea?
Yes.
Raise your right hand for me, please. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
All right, who's going to void dear Mr. Johnson with respect to the factual basis?
I can, Your Honor.
All right, you may.
Mr. Johnson, on July 27th, 2021, were you at the Motor City Casino in the city of Detroit?
Yes.
And on that date, did you pound a button on a slot machine hard enough to damage it?
Yes.
And it's because you were angry at the slot machine?
Yes.
And do you believe that the value of that button is $417.64?
Yes.
Judge, I think that should be sufficient for the factual basis.
Are the people satisfied?
People are satisfied, Your Honor.
All right, the court is satisfied, and I will accept a guilty plea to one count of malicious destruction of property. Having accepted the guilty plea, my question to the people is understanding that someone from Motor City Casino would have a right to come and speak to the court with respect to sentencing. It appears that there has been already restitution included in the people's offer. Is there any objection to immediate sentencing?
There is not, Your Honor. And in doing so, I would merely request that the court or its clerk provide how the defendant may pay this restitution into the court in favor of the Motor City Casino.
Okay. What in the world happened? Mr. Frazier, is there any objection to immediate sentencing?
No, Your Honor.
All right. Would the people like to make any other statement with respect to sentencing?
The only request that, Your Honor, that the people would have is some period of probation sufficient to verify that whatever mechanism of payment is made for the restitution, any court costs, fees, or fines, in fact, clear this honorable court. And that way, the court would maintain jurisdiction over the defendant until those fees, fines, and restitution are paid, and whatever period Your Honor feels is appropriate for the crime that the defendant has pleaded guilty to.
I'm sorry, I muted myself because my printer was loud. Anything from the defense with respect to sentencing?
Just briefly, Your Honor, Mr. Johnson is retired. He does have the funds. He intends to pay the restitution and any fine that the court imposes today, if possible, either by going to the court and paying it, or if it can be paid online, he will do that. Mr. Johnson has no felonies. He does have a few misdemeanors on his record, but nothing serious and nothing involving the destruction of property. This was an isolated incident. He was at the casino and probably losing money to the slot machine, and took out his frustration on the machine, causing minor damage. I just asked the court to consider those things, to delay this under section 771.1 and to impose whatever reasonable sanctions that the court feels is appropriate.
Your Honor, you're muted.
Thank you. Would Mr. Johnson like to address the court on his own behalf?
Yes.
You may.
I'd just like to get this over with.
Okay. The court is ready to impose sentence and will do so as follows. I will accept the recommendation for a delayed sentence under 771.1. Court is going to impose a probationary period of 6 months with a midway review date of May the strike the May, because I'm gonna be going. All right, with a midway review of June 4th at 10 o'clock, and a final review of August the 23rd. If we get that far, the 6-month probationary term, of course, comes with the opportunity for an early discharge at the first review. Court is going to impose the following conditions. You shall not violate any criminal law of any governmental unit. You cannot leave the state without consent of the court. You are to have no contact with the complaining witness. You will pay the following fines, costs, and fees: $210 mandatory cost, a $200 fine, and give me the exact amount of the restitution. 400.
Your Honor, it is $417.64.
$417.64. This is going to be a reporting probation. However, you will report to probation and you don't necessarily have to report on a monthly basis if they don't want you to, but I am going to impose reduced supervision fees. You do have to report to probation in order to get a referral for one of the conditions that I'm going to set. So I'm going to impose oversight fees at a rate of $15 a month instead of $35 a month. And for 6 months, that amount is $90, which will be cut in half if you complete the probation early. The total fines, costs, and fees are $917.64. You shall also not use or possess any illegal substances. You shall not drive without a valid driver's license. You shall attend 6 weeks of anger management through eVay. And those are the conditions of the court. Mr. Frazier, please call my courtroom at the conclusion of this hearing. Did I cover everything that the people requested?
Yes, Your Honor.
Thank you.
The only thing, I don't know if there's a way to specify to the defendant how it is that the restitution gets paid. We'll provide the Motor City Casino payee to Your Honor's clerk if the court does not have that. And I don't know if Your Honor is inclined to have restitution be paid first in the event the defendant makes part of it.
So,
Your Honor, the defendant will pay all this today.
Those are all things that goes through probation. However, the court does, you should give the payee information to Mr. Flanagan, because the court will then submit the payment upon receipt to directly to the casino. Okay.
Thank you, Your Honor.
You're welcome. And then, Mr. Frazier, please call the courtroom so that we can make sure we have Mr. Johnson's current address and phone number so that probation can contact him with respect to the anger management. And and then in order to be discharged early, if he's going to pay everything today and he feels that he's going to finish the anger management within that first 3 months, excuse me, then he only has to pay today. Let's see, 917 minus Oops. Oh. So today he would have to pay $872.64. That's his total for the first 3 months. That's his total. And then if he was just continue, we would just add the other back. But probation has to give the referral for the anger management for the EVA program, or if that's not conducive to his particular schedule, then probation will give him another referral. All right, anything further?
Judges, I know the clerk is busy right now. I didn't email the plea agreement over. Should I email Mr. Johnson's current contact information? Would that be easier for the clerk?
You can, yes.
Okay, I'll take care of that immediately. Do you believe that, will he be able to pay this online today?
Yes, I'm sure Mr. Flanagan has already probably inputted, so he could pay it online today. It won't take effect. I shouldn't say it won't take effect. It doesn't populate the system until like 7 days. So by next week we'll have the payment.
Okay. And he'll be contacted by probation
Yes, for the anger
for the
management.
anger management. Oh, okay. Thank you, Your Honor.
All right, you're welcome. Have a great day.
Thank
Stay
you.
safe. You're welcome.
Thank you, Judge.
You're welcome. Oh, okay. Oh, working nonstop today. Miss, I think I'm gonna do it like this. Oh, Miss Ripley.
Yes, Judge, good morning.
Good morning. Miss Ripley, you sent me a message in the chat, and you said that I should be expecting an individual named Matthews.
Yes,
And-
Judge, that's her last name. I'm not sure what she would be entering Zoom by, though.
So just for your information, there's everyone in the Zoom is known to the court in terms of being on the docket or something, and she's not there. So I was trying to, so I'm getting ready to do a couple of other quick cases and then get to the sentencing. So if she's planning on coming, you may want to call her or let her know I'm getting ready to do the case in a minute.
Yes, Judge, I'll give her a call.
Okay. All right.
Thank you.
Okay, you're welcome. Okay. So I'm going to do Yerger. Where's my docket? I'm going to do Yerger, and then Miss Stevenson. I'll do. I think other than my sentencing, that will complete all of my retained counsel. So I'm going to do Yerger, and then I'll do Dials, and then I'll do. Oh, you have a sentencing, Miss Stevenson. But I'll do yours after I do Mr. Pilgrim's. Miss Stevenson, do you have? Oh, let's go ahead and do. I'll do Harrison after Yerger. That's quick for sure. Mr. Yerger, can you start your video? And then I'll bring in these other people that you have to talk to, Miss Stevenson.
I don't see Mr. Yerger in the Zoom breakout room. I don't know if he was let in.
No, he's here. He just needs to start his video. I'm looking dead at his name. He's not. He may be not at the computer.
Oh, there he is.
Yeah. Okay. Okay, I'm ready on Yerger. This is case number 234521501. The People versus Carl Henry Yerger. The defendant is charged with 1 count of weapons. The docket says weapons, firearm, and I don't know what else that means. Ms. Ritter, you can put it on the record when you place your appearance, please. Appearances.
For the record, Your Honor, Christina Ritter on behalf of the people. And Your Honor, I believe the charge is reckless use of a weapon.
Okay, thank you.
Good morning, Judge. One of your staff, Caitlin Crapo, P86272. On behalf of Mr. Yerger, we appear via Zoom. Mr. Yerger, could you unmute and place your name on the record, please? You just have to click the little microphone.
Hello? Can you hear me?
State your name, sir. State your name.
My name is Carl H. Yerger III.
Thank you, sir. Today is the date set. Does the H stand for Henry, Mr. Yerger?
Yes, ma'am. Yes, Your Honor.
Today is the date set for final pretrial conference. Ms. Crapo, how are you proceeding?
Your Honor, at this time, we would like, Mr. Yeager would like to invoke his rights to a jury trial. We would like to set this for jury trial.
Court is going to continue a not guilty plea. On behalf of Mr. Yerger and set the matter for jury trial, my next available, well, the next date that I'm giving for jury trials is September the 23rd, council. Is that a good date?
Yep, I have nothing past
right.
set past June at this point, so.
All right, so the court will set September the 23rd. With the final pretrial conference of August the 26th. So the situation is this, Ms. Yerger, there are 2 other jury trials scheduled for that same day. Their final pretrial conference is August 23rd. And then, so if those settle out, then yours will be up. If those do not settle out, and then I'll have to move yours to another week, but that's how that's working, okay?
Absolutely, Judge. Thank you. And when it pertains to things like jury instructions and witness lists, when do you prefer those to be filed by?
Well, anything, I'm going to give the standard jury instructions, and so you don't have to file any jury instructions unless, let's see, what is he? Oh, yeah. So you probably do need to file jury instruction on the weapons charge. Let me know what you want. So I'm going to do all the standards. If you have a special or if there's